This is always one of our most popular panels. It's a federal judges panel, and we're very happy to have Bill Shepard from Holland and Knight moderating this afternoon's panel, and very glad that Bill was able to make it here from West Palm Beach through the Hurricane Dorian. Apparently Bill showed up at the airport ready for his flight, and everything was there except for any airplanes, but
not a single plane at the airport.
He made it, and he'll be flying immediately back. So we're happy to have Bill. Bill's a partner at Holland and Knight and works out of the West Palm Beach and Washington, D.C. offices. Bill's a managing partner of the West Palm office, and Bill served as the head of the ABA's criminal justice section. He's involved in a number of criminal and civil investigations, including many healthcare fraud matters. And Bill has long been a vocal and persuasive defender against government overreach and overcriminalization. If you want to learn a little bit more about Bill and his background, I encourage you to read his article that he authored for the Wall Street Journal in 2014 called Something Fishy in Sarbox Land. And if you can pull him aside, he's got some pretty funny stories about a United States Supreme Court case called Yates versus United States, and was representing NACDL, who filed an amicus brief in that matter. And Bill has long been a big proponent and friend of this program, and we're happy to have him back. Thank you, Bill.
Well, thank you. And thank you, Brian, for what you guys have done. You and Joe and Mitch have worked on this conference for years. The roster of people who are speaking today and tomorrow, I know you have General Carr, I know you have the Solicitor General come in. I mean, it's just, it's remarkable what you guys have built in this program, and in large part due to the people in the audience who participate. And we hope that this panel is no exception, because you see, Judge Wood was going to be on this panel, so we were going to have another speaker, but she is dealing with a speedy trial problem. So work comes before panels, and so even though I was delayed by the hurricane, she is not letting that stop her in her trial, even though I understand they may be getting some exposure to Dorian right now. But this is a great opportunity, I think, for those of us who practice before the judges of our states to actually have a little bit of a dialogue with them. And even though I will be leading some of this dialogue, I would hope that all of you would feel free to ask non-case specific respectful questions if you have any, and I know that you would. But we're fortunate because we have a former chief judge from his district, and Judge Sands, who has served on the bench after his appointment by President Clinton. I am, as my father and uncle, who were both Marines, would tell you, I am the only civilian screw-up on this panel. Both judges served in the United States Army with distinction and have continued their service to our country now on the federal bench. To his left on this panel is the newest judge, I believe still the newest judge.
Only until next week.
Okay, very good, very good. So it's short-lived. Last year we had Judge Brown, Michael Brown, who was at the time the newest judge, but now outranks you by many months, and I'm sure, since I went to college with him, I know he's probably using that leverage on a daily basis against his newest colleagues.
I had to drive him to lunch yesterday. So yeah.
Comes as no surprise. This is a great opportunity. The title of it is sentencing, but really in our discussions leading up to this, there's an opportunity to have a much broader discussion and to talk about a variety of matters that come before the court, whether those are pre-trial matters, trial matters, or post-trial in the sentencing. And I think there are opportunities that overlap, as some of our own practices and some of our own cases do, between sort of civil and criminal issues. Some of the issues that we can address this afternoon cross both lines, and whether it's a key TAM case that has hints of criminal components to it, or securities fraud sentencings that also have civil pieces to them. I think there are opportunities to discuss that from the get-go. But Judge Boulee, if you wouldn't mind, since you are the newest judge, if you'd like to just introduce yourself a little bit to the crowd. I know people may have appeared before you in state court, practiced with you as co-counsel, or perhaps even as partners and colleagues at Jones Day. But you now have taken on this new role, and I think it would be interesting for the audience to hear about your approach to that and your decision process towards making that move, and how you have approached it so far.
Sure. Well, first off, I'm delighted to be here. I want to thank Brian McAvoy for the invitation, and Bill, thank you for leading our group. As far as the transition, it was interesting. I got to sit down with my now fellow judges over the last couple months, and the only person I didn't sit down with was Judge Murphy, but I'm intending to drive to Rome and hopefully get to talk with him in person at some point. But I did talk with him over the phone, and he told me that, he said, JP, you now have the best job in the world. You get to go in every day and enforce the Constitution. And that's how I see it. And, God willing, I'll get to enforce the Constitution as long as he has. As far as my background, I look out, and this is almost a homecoming of sorts. I did practice business litigation and what they call corporate criminal investigations at Jones Day with Rick Dean and his crew for 14 years, and I got to know a lot of you then. And then when I was appointed to the Superior Court bench, I kind of disappeared, or you disappeared. I don't know which it is, but I didn't really see much of this federal white collar group. Every once in a while, you may have wound up in Superior Court for some strange reason, but it was certainly infrequent. And I'm very glad to be back and now get to handle some of these cases again. It was one of the most rewarding aspects of my time at Jones Day to work with some of you. So happy to be back, I guess, as it were. As far as background, before I was at Jones Day, I was in the JAG Corps, as Bill mentioned. I was what they call a trial counsel in the JAG Corps for a little over a year, and that's essentially both a prosecutor and a operational law advisor for an infantry brigade. And then for the last 2 years in the JAG Corps, I was in the Trial Defense Service, which I guess is the equivalent of a federal public defender in the Army. And I think that was incredibly valuable experience for me once I was on the bench, because I've seen these criminal cases from both sides of the aisle, and I think that's really been helpful for me. When a public defender comes up to me in court and says, Judge, I'm just not ready. I've got 50 cases and 20 of them are murder cases, and I'm not ready. I think I can hear that because I've been there. And before that, I was a clerk for Judge Evans, who was really happy to have her swear me in just a couple weeks ago. So that's kind of the bio. And I can get into some of my other thoughts.
No. I think that's great. And I note, Judge Sands, in your own background, you were a prosecutor for a number of years, both state and federal.
Yes.
But really one of the things, and as Judge Boulee was talking about, the work that he did as a trial counsel in the JAG Corps, representing people and standing beside an individual. And I would encourage you all to review Judge Boulee's materials as part of his Senate confirmation, where he talked about some of those cases, as he's required to do in the application. But some were very impassioned fact patterns that I think those of us who have sat with a client at their darkest hour and tried to help them understand the process that may be so foreign to them. Judge Sands, it reminded me of your remarks at the graduation, speaking to law students at Mercer, your own school, talking about an early client that you had in private practice, and a woman who you stood beside to help on a day that was important to her. Those things that become part of our life or part of our history, you certainly have to take to the bench with you.
Yeah, I agree very much. And also, I'd like to say I'm happy to be back again, too. I think there's a famous literary comment that goes something like, "You can't go home again." And I guess if you're invited again to a seminar you've been to before, it means it's kind of going home again. So, Joe, I appreciate it very much. And I appreciate all of you all being here this afternoon. It's after 3 o'clock or after 2. And you're still wide awake and listening and hoping to interact. So I'm very pleased to be here. But I think our life experiences do make a great difference. As Judge Boulee said, I too did state and federal prosecution. And I also did some defense work before coming on the bench. And that really changed my perspective quite a bit. I thought I was a fair prosecutor and I saw both sides of it, but I didn't really appreciate it until I did actually go into private practice and actually have counsel of clients that I had to deal with. And then at a real level, fully appreciated what it was like to sit with that client and to not have the power of the state or the federal government behind you in doing your work. And that has come with me to the federal bench. And as Judge Boulee says, I can hear both sides, I think, because I can relate to both of them. And sometimes having only a prosecutorial background, you don't have the depth of experience or sensitivity, maybe a better way of putting it, than you might have otherwise. But I think we all bring with us our experiences.
When we're looking at a case and trying to assess a case as a lawyer, whether it's as a prosecutor or defense counsel, I think one of the first steps we're trying to think about is how we're going to make that presentation to the court, how we're going to make that presentation to the jury. And you're trying to frame the issues, you're trying to get the narrative arc, so to speak, the storytelling of what it's going to be. But fundamentally, you have to use the vehicles and the different platforms that we have to speak to the court in advance to start telling that story. Judge Sands, if you could talk about some of those early phases of the case, even sometimes the pre-arrest phases, where you might be in on a motion to quash a subpoena, or immediate after arrest, and you're there on bond and you're arguing detention. I realize some of these issues are before the magistrate judges as well, but over your years of experience, how would you say is best to approach those issues to help educate the court on some of the things that may be happening months down the road?
Yeah, I think the rule is always, I've always sort of preached this, is prepare, prepare, prepare. And you mentioned the early stages of the case. I've always advocated, whether it's a civil case or whether it's a criminal case, that one, to the degree you can, sometimes time is not available to you, but if you possibly can, at your earliest convenience, you have to think a case through. And what I like to say about it is to take the various angles of the case that you have, the different routes you could take with it, and what would be the consequences based on which direction it went and how things played for you one way or the other. I don't think you can really handle a case appropriately or at its best without having thought it through. I don't think you can just storm from one stage to the next and see what happens, and it happens. I don't think it happens so effectively. So I think when you say things like pretrial matters or bond, I think one of the primary things to be thought about, particularly in criminal cases, is this going to be a case that's going to be a fight to the finish, or is it going to be a case where hopefully there'll be some meaningful compromise and some favorable way of resolving the case? And I think that decision alone is going to decide how you may go about it, because you will not be as aggressive if it's going to be a case and you hope to work some things out. So you're going to think about it and approach it differently with both before the court and before the with the opposing party. I think the critical thing is to be frank with the court when it comes to the court, whether it's a magistrate court judge or whether it's the district judge, superior court judge, is always remember, and I know you've been told this since the time you were in law school, is your personal integrity is the most valuable asset that you have, no matter how well prepared you are and talented you might be otherwise, in particular in doing court work and trial work. Your integrity means everything. And you don't ever give that away or blow it for a short-term gain. It's not worth it to you, because that's what, again, makes a difference. As Judge Boulee just said a few moments ago, he knows what it feels like to be the person who's not prepared yet. And you got to recognize there are judges on the bench who have different experiences of that same kind and other kind. And when you approach them with that integrity and they know that you are a person who is consistently showing a good integrity, so when you ask, you're much more likely to receive what it is that you're asking for or something close to it. On the flip side of that, if that integrity is harmed, it is not going to bode well for you. It may have gotten you short-term what you wanted, but it's going to hurt in terms of your presentation before that judge again. And if that judge shares what the judge observes, it's going to multiply itself out in that way. So I would say maintain your integrity at all times, because it's going to benefit you, your client, and clients in the future, and your appearances in the future. And to think the case through so you can move along in a way that's measurable. The one last thing I want to say before I let Judge Boulee give his part is this. I learned as a trial lawyer two ways of looking at a case. When I had a legal question or some legal theory that I was wondering that would work or not, or how to approach it, I always talked to fellow lawyers. And get, you know how we lawyers are. We can take the finest point and turn it into 30 minutes of serious argument. But if you want to talk about the facts of a case, when I said, what is the case, think through the case, is this a trial case, or is this a case to be worked out? Talk about that to lay people. If you want to get a trial test of your case or get some idea of how it might be, you don't want to talk to another lawyer about it. The lawyers tell you all the legal things that you can do, all the motions you can file. And if you can tell the story, you can tell it very plain, and you start telling this to someone who's not a lawyer, and they'll say, "What? Are you kidding?" You know that balloon is not going to float. Because they can say to you in very plain language that doesn't make any sense. On the other hand, if something is a case that's very a tough case that has a very serious charge, and you start telling the story, and the client kind of says, the person says something like, "Well, yeah, but I don't understand that. I don't, that's a pretty bad charge. But I've got a question here," and the thing that they point out to you are probably going to be key things about your case that you need to be looking at. So that different ear, because as lawyers and judges, we get so used to legalisms. I think at Mercer, I think Judge J. Taylor Phillip, who worked in the state courts for years, he used to use juries from high school for his mock trials. And when he couldn't get one of them, he would have the law students from the other classes be the jurors. And he said statistically, every time he had high school students, they would always decide the case the same way as the real case that the situation was based on, that the Mark case was based on. And the law students always made a different decision. So that's kind of another way of saying the same thing. That's the point. You've got to get your law right, obviously. If you can't get that right, you're not going to be very successful. But I think you'll find to talk to It may be a family member, somebody who would just be honest with you. You just, you don't even need to tell them why you're telling them necessarily. You just kind of say, what do you think about this? Let me tell you something. But you'd be surprised at the great benefit that you would get in seeing things the way a normal person who's not burdened with the law, like in other words, how a jury would see it. So that's some of the way I would look at the early stages as a part of approaching the case.
Thank you, Judge. Judge Boulee, when the case first comes to you and you are meeting the prosecutor, you're meeting the defense lawyer, and you're seeing the agents in the back of the room and the defendant brought out, you've worked in the court system for years, so you understand the process, but nonetheless, there's a bit of a challenge there because the client is oftentimes in shackles and although legally presumed innocent, stands in an awkward position. How is it that you think it's best for defense counsel to make that first approach to you or presentation to you at those early stages? Again, sometimes we're talking about it in a bond context or a review of a detention decision that's already been made. Other times we're talking about it where we're fighting over discovery because that initial decision of am I gonna fight this out or am I gonna try and come to a good compromise? Either the decision has been made, I'm gonna fight this to the end, or the decision is I just don't know enough yet. I don't have enough visibility into the government's view of the world, and I need to fight for some discovery. And I need to see what's out there. So help us understand your approach to those kinds of early issues.
Well, here's a good practice tip I'll share with you. If you're there on bond or something, don't lead with telling me how old your client is. I know that if all you've got is to tell me he's 19 years old, or she, that there's probably not much there. So don't do that. Never lead with how old your client is without any additional information. That's kind of a dead giveaway that there might be some bad things in this individual's past. The converse of that is, do tell me something about your client. And again, I recognize, and it's a little bit different in federal court, white collar practice than it is down in the trenches of Superior Court and a public defender. But, no matter how many cases you have, for that individual's case on that morning or that afternoon, take the time to have gotten to know your client, something more than how old he or she is, and tell me a little bit about them to make them a person as opposed to just another number on my docket of, in Superior Court, 20 or 30 cases that day. And I think judges, I think every single one of us, we want to follow the law and get it right and treat every person before us fairly. So just let us know about your client, make sure that we have the law, and we'll do our best.
Mm-hmm. Where do you see it's appropriate to bring in other people to narrate that story in the terms of witnesses, employers, some sort of medical expert who might want to give the court a more fulsome picture of the client early on in the stage? I mean, the panel before this, there was a lot of discussion of opioid cases.
Right.
Those cases are very unique in the people who are charged oftentimes, right. Who have a whole history that have led them into the situation they find themselves in.
Yeah, I think that can be incredibly effective to bring someone else in who knows the individual, whether it's an employer, a teacher, a close family member. And I would say, finding 2 or 3 of those folks who know him or her well is infinitely more effective than, passing me up 12 letters from aunts, uncles, cousins, next door neighbors, brothers, sisters, friends of friends. I think, I read those too, but I think it's more effective if you have 2 or 3 people who know him or her well. Most definitely. Judge. I don't know if you agree or disagree.
Yeah, I agree with that. Another thing I did want to add, though, we had a probation officer to retire a few weeks ago, and he was a person who prepared pre-detention reports. One of the things about federal court is, unlike superior court, you've got a lot more support and resources, than you would have, particularly when I was there some years ago as a superior court judge. Hopefully it has improved. But a lot of that information that will be going to the magistrate judge and maybe ultimately to the district judge if it gets that far. Most of the information is going to come from that probation officer. And the officer was talking to me and he said, one thing, he says, I wanted to tell someone and I didn't know how to say it to them. And he said, I want to tell the public defenders that I'm not your enemy, And what he was feeling was that sometimes the situation gets so severe in terms of the litigation between the parties, so the parties confuse some players as being a part of the game of opposition, and they're not. The probation officer is there basically to help the judge come to a good decision and get that information. And he gave some examples of things he had tried to suggest to lawyers, like, you might want to look at this or point this out. And somehow the particular lawyers he was thinking about did not see it that way. They thought that he was somehow trying to make life difficult for them, and they kind of shooed the help, and it was not beneficial to them. And so I would just throw that out. I thought that was interesting that he said that, and I definitely know that the magistrate is going to take what he says very much into consideration. I would, if I was looking at it again as an appeal, or occasionally I will do an arraignment if the magistrate is not available, and I would hear that information. So that's important information. So someone who has the ear of the judge as a routine way is going to know what's likely to make a difference and what's not, and will probably give you some information. So I would say that you need to take that into account also. And I certainly agree that one or two people who really know somebody and can really give some real information is much more valuable than a stack of papers. To get into sentencing is where I would normally see this, and I've had people send me reams of letters, and I think word got out that I actually read the letters. If you bring me 150 letters from people, I will read them, I assure you. Now, there's a danger in reading them, because within 2 letters, I will know whether it's a form letter that has been basically outlined by somebody, and everybody's writing me the same thing, so that's all going downhill very quickly. And they may, if they're actually letters written freely by the person, anybody who's willing to write one, it may not necessarily be beneficial to your client. They may see it quite differently and will tell me so. What I find effective is, as Judge Boulee said, letters that come from someone who really knows the person. And they are sharing more of their experience of what they know about that person than to argue the case for the person. They usually just admit, if this happened, it happened. I'm not trying to fight that at all. I'm not trying to say it's not true. I've had people say to me, he's obviously not guilty. Of course, I know that I said at the trial. There's someone is, they're doing him in, they fix this case on him, so that letter goes that way. But the type of letter, though, that's of someone that shows a real understanding. The 2 greatest sentencing statements that impressed me the most, I'll say. One was in court. A fellow had robbed a bank, and he had been caught within an hour of the time that he committed it. He played trumpet in the local orchestra, and he was a school teacher. I mean, he was caught red-handed. But at his sentencing, in fact, he had 2 people there. He had his ex-wife there, and he had his best friend there. His ex-wife said, well, he asked me to be here, so I'm here. She was one that you probably should have left out.
That sounds like he might have been trying to lay ineffective assistance at counsel, right?
Maybe so.
That could have been the strategy there.
But his other person, this gentleman that was there, he said, well, Judge, I'm surprised about this too. I'm so far out, I don't understand why he did this. He said, but what I want you to know is that we're friends. He has a son, and I have a son about the same age. And he says, his son stays at my house with my son sometimes. My son visits at his house sometimes. And he said, I've been welcomed at his home for dinner and events. And he's been welcomed at my home. And he says, and when he's finished serving his time, he'll still be welcome at my home. That to me was a powerful statement because it was speaking of his feeling about this person beyond the charge. And that was very impacting. And the second example that I had was a letter I got, and I'm sure a lot of you who do white collar, you have people who are very prominent, people who are wealthy or have very high positions in society, and they are sometimes, as I used to hear Joe say, the rich and the famous have a right to a fair trial too. And something that can be forgotten because a person has so much influence, they don't have anybody in there cheering for them at that time. They're seen as it's time to get even. And the fellow was like that. He was from a very prominent family, had a lot of property and all, and both the state and the federal government were trying to take property that had been in his family for generations. And I got a lot of letters in his case too. But there was one letter that I got that was really unsolicited. And it's from a young woman. She said, Judge, he doesn't know I'm writing you this letter. And I don't know much about his case, but I heard he's in trouble. But I want you to know something about him. And they had gone to high school together. And this was a high school where there were very wealthy, a small group of very wealthy kids in the school. And everybody else was poor or middle class. And the rich kids ran together and constantly reminded everybody of their wealth and distinction. They would have to have their parties and such. And this young lady, she said, well, I wasn't in that group, to go to all the special parties and that sort of thing. She says, but I remember he always spoke to me, because apparently it was not even appropriate to act outside of your group. He always made sure that I realized that he realized that I was there. He would speak to me and invite me to his parties. And that was a particular thing that had happened where she had been placed in a situation that was disadvantageous, and he had stepped up for her. And she recognized that he was of a different group and a different class, but he had never treated her that way, and that instead he was really a decent person. And she wanted me to know that she thought that of him. And a couple other people spoke the same way in that group. And what I'm saying is this, and this is when it comes to people knowing someone, as Judge Boulee said, this person's character came through a couple of different people out of different situations. And sometimes when you're trying to represent someone like that, you're trying to get the judge to understand that, but it sounds so recently created. Everybody says, well, he's really a nice person, he's a great guy, but the same people who are saying this are folk just like that person. So it doesn't have any heft to it. But that person who's outside of that group, who has no obligation, no reason they have to come forward. She had not even been asked to write a letter, but she gave an aspect of his personality and character that was very significant to me, that I appreciated, that matched with a few other people. Unlike the person who says, this is a great guy because actually he changed the lights at the tennis court one night before everybody got there. This in another sentencing, a person was speaking that this particular defendant was a really fine person because he would lower himself to the level of changing a bulb, you know, at a sports place, you know. Not a good.
I could see how that might not be the most compelling approach.
That was not compelling, apparently from
But
their.
sometimes you got to work with what you got.
But I thought that was just an our perspective. You know, does anyone remember? We talked about everybody being I guess I'm a middle boomer, early late boomer. So anybody remember Gulliver's Travels? You may have seen the reruns of it. Not Gulliver. That was not Gulliver's
Gilligan's
Travels.
Island.
Gilligan's Island. And you know the Howells. You know, Mr. Thurston Howell, who's the billionaire. And she said, his wife asked, she says, Thurston, what's that on your face? And he says, I don't know, Levy. What is it? What is it? She finally said, it's perspiration. I've seen it on our gardener. So that statement by the tennis show, he got there first and the lights were out, you know, and he got a ladder and got up and changed the lights. So I guess from within that circle, that was impressive, but among regular people, that did not go over well. But,
and I think it's probably difficult sometimes for people to step away from their own case and realize what the judge sees all day, every day, right? So, you know, you see tragedy parade before you on a regular basis. And people who want to talk about what is tragic in their life, you know, it's not as compelling, even though it's impactful to them. They have to understand the audience they're speaking to. And really, Judge, you've been talking about the sort of the common man witness, the person who comes before you and speaks from the heart. Judge Boulee, you know, the other piece of this is the expert witness. And whether it's in state court or federal court, expert witnesses, I think, are taking on a greater role. People are trying to use them in greater and new ways, in ways that maybe people hadn't thought about before. In Florida, where I practice mostly, we've just had a major battle in the state courts and the legislature about whether we would have Daubert or Fry. It was a decades-long battle that really had to do more with the civil bar than the criminal bar. Interestingly, the defense bar and the state criminal courts, for the most part, was in favor of Daubert, a higher standard, and would point to cases like the notorious dog whisperer from DeLand, who was a sheriff's deputy whose dog only caught guilty people. There was a smellologist who had testified that his nose had been specially trained and he could open a trunk and determine how long a body had actually been in there and place a time of death based on his expert nasal skills. We now have Daubert in Florida. Brian talked earlier about the fish case I was involved in, U.S. versus Yates. There was a Daubert hearing on fish measuring and whether you measure a fish with the tail closed or the tail open, and has a very significant impact. And in fact, in that case, that government witness who was going to testify about fish size, by the time the Daubert hearing had concluded and the federal defender had finished with him, it was clear he was really going to be a defense witness. And a issue before the Court of Appeals, the government objected and said, well, he's not a listed defense witness, Judge. How could we possibly be prepared? They have this list of witnesses and his name's not on there. The argument, of course, was made to the trial judge that, well, he's their own witness. They've prepared him. They paid for his expert report. They flew him here. They've talked to him hundreds of times. But that did not prevail and didn't make its way to the Court of Appeals. But I give all that background by way of saying there are new ways to use experts. Big data that was the panel before this, and the role that experts can play in that. How do you think people can best think about experts in their cases. How can they present the expert? And ultimately, how can the experts be effectively challenged? Because lots of times people come up with great theories, but if it's something that deserves challenging, just as the big data panel talked about how maybe the big data should be measured as an informant for reliability in search warrants, just the way human informants would be. I think there's going to be a change in how we're looking at all these things, and I'd be interested in your view of experts and how that can play out.
Sure. Well, I'm delighted that this session has devolved into stories about fish size. And
Yes,
I
thank
could
you.
actually
Right?
probably wax poetic on that. And just one quick tip.
None of which got away.
One quick tip for the audience is if you're taking a picture of a fish, you want to hold the fish out as far as you can in front of you, really close to the camera lens. So that'll make a 6-inch guppy look like an 18-inch fish. And I do know that trick.
Very good.
As far as expert witnesses, I look out at this audience of all these experienced white-collar practitioners, and I think most of y'all probably know as much, if not more, than I know on expert witnesses. So I don't know that I could give you a lot of benefit there, but maybe what I could add to the conversation is I have spent the last 4 years sitting up on the bench, watching people present expert witnesses, and also watching the jury, which is something that I think sometimes counsel lose track of. You're so involved in your outline and your witness that you don't pay attention to the jury. And I think good attorneys, with an expert especially, will keep an eye, really any witness, but will keep an eye on the jury because, there is a short way and a long way to do every witness. Mm-hmm. And I think with expert witnesses, sometimes attorneys will think that the long way is the best. I mean, this person, they're from Harvard. No offense to anyone from Harvard. And they bill $1,000 an hour. They're the best.
No offense to anyone who bills $1,000 an hour.
They're the best in the fish size measuring business. And so, I'm going to give a 3-hour background and then have them talk about anything and everything about fish size. And you lose track of the jury and the fact that they're looking up at the ceiling tiles after the first 15 minutes. And I mention it as to experts because that's where I've seen it happen time and time again. Thomas Carlyle's speech is silver, silence is golden. In the Army, you probably learned, keep it simple, stupid,
That's right.
kiss, right? And I think that really holds true with expert witnesses. Be careful about how involved you need to get.
Right.
I think usually you're more apt to err on the side of too little.
Yeah. Well, Judge Sands, sometimes though these cases become complicated, and if it's a healthcare fraud case and we need experts to explain billing issues or statistical analysis, sometimes you feel like you need somebody whose qualification is greater than he's got a briefcase and he's from more than 50 miles away, which is the standard for experts in some parts of Florida. But have you seen experts challenged effectively and excluded experts over the years that you could share with the audience?
Yeah, I agree. When you mentioned Fry and Dalbert, and so early Dalbert, it was a frightening sort of task.
Right.
It still is a bit of a challenge for the trial judge. But as we've gone on, we've got better instruction and we've got a better idea of what is required. And I have in fact seen experts who were challenged and challenged successfully, and where it's clear that the witness is not testifying with regard to an issue that's actually in the case, or that they don't have actual experience or training in the area that they're giving an opinion about. It can be done, and I've had cases where it has been done successfully. But it's a pretty big task. I would suggest that you only do it when you believe you actually have an unqualified expert. I think just to beat up on an expert who's ultimately going to be approved and left to the jury won't bear well with you again. Again, it gets back to what I said earlier about integrity. In other words, if you attack witnesses routinely without regard to whether you have a genuine basis to do so, that's going to wear on the judge. Where if you took a better approach, then when you do have those issues, they'll be heard more likely. As Judge Boulee mentioned, there are two types of expert witnesses I've watched as far as those who testify before juries. There's the group that says, I'm the smartest person in the world. I'm so smart you've probably never seen anyone, will not again see anyone as smart as I am. And what I'm going to talk about is so complex that you could never hope to understand it. So you should just accept whatever I tell you, and that's all you need to know. And that's when the jury starts watching the ceiling and they will not pay any attention to it. And then there's the expert witness who says, I know this sounds complicated, ladies and gentlemen, but bear with me for a moment. It's not really. I can, if you just listen to me, I think I can show you why this makes sense. And they engage the jury. You can almost see the jury, like, wow, you're right. And when he mentions the fact about of paying attention, that's where if the lawyer is not paying attention, he won't pick this up. And that's another tip that I'll give you. I always advocate that to be a good trial lawyer, you have got to live in the present. And what I mean by that, you have got to be present in the case. You've got to be knowing what's going on now, as Judge Boulee said. So you will see how that witness is testifying or not, how the jury is reacting. You can't be reading the next witness's statement or reviewing the next witness's deposition or writing great notes that you're going to review the night afterwards. It's got to be in the now, which requires you to be super prepared. That's why the work is so difficult to do well. You've got to be so super prepared in the beginning to free you to be in that state of presence in a trial, to hear that slight change in the witness's statement that's significant. Because you say, oh, now I see. Or that witness who just hesitates ever so slightly, just the slightest. And if you're looking down, taking notes to make sure you can accurately state what he said, and that hesitancy that the witness showed to the last question, which is a signal to you that there's just something about that answer that says there's a problem here, and this is probably where I need to concentrate. So the not understanding the impact of an expert witness, all that goes back to this idea of it being present if you're going to be a trial lawyer. That's what you have got to be now. Because you got to decide quickly to do something or not do something, or what to do or what not to do. And you can't do it well if you don't have all the information and all the inputs that are coming into you at one time. But I'll just throw that out as a reminder.
No, and it's a good reminder, especially when you're in trial, because at that point, or whether it's a hearing or a trial, right? Mm-hmm. At that point, your strategy has already been laid, and you're acting on the things that are happening in front of you. Right. But let's take a step back, Judge Boulee, if we could, and as we're thinking about trial, we've worked through some of the issues with our client. The decision is we're going forward to trial. We've gotten the discovery that we're going to get. We've had our expert battles. We're trying really to set the stage for the trial itself. one of the areas that the three of us have talked about that is an area that's a tool that lawyers can use very effectively to help set those guardrails in the trial where they have more time to argue it, and it's not on the fly, is in the motions in limine. And it's the ability to tell that motion story to the judge who's going to ultimately hear the case, who may for the first time be really learning about the case because you may have done a lot of the pretrial work with the magistrate. So it's an opportunity to raise some of those issues which are going to dictate some of your trial strategy based on those motion in limine rulings, but also put the other side on notice about what they're going to be allowed to get away with too. But sometimes people who try lots of cases, they have the same 15 motions in limine they file in all their cases. And today's Tuesday, I'm picking another jury, and here's my 15 motions. Is it an area that lawyers can do better in? And how would you help us all think about how to take advantage of that motion in limine opportunity strategically?
Yeah. Well, my answer is not really federal court, it's more superior court where I've been the last 4 years. And I think, the folks that were in front of me did a great job of that. I would say, as far as a practice tip, is try to think of as much as you can about motions in limine at the front end. And it's certainly a little bit more formalized in federal court than it is in superior court. But going in for various witnesses and various topics that you're going to object to it. So, I think it's beneficial for all concerned, really, unless you think it's a good idea to have the jury have to wait around for an hour here and there throughout the trial, which I don't think that's good for anybody.
Depends how bad your facts are.
Yeah.
But
bring it up at the outset, and don't just think of your routine motions in limine, but think through your evidence and think through where you're going to have disputes in advance of trial, and ask the judge, hey, can we have an extra, half of a day before we pick the jury, so that you don't, in the middle of trial, have to take these long breaks. I don't think any judge likes it when, at 10:45 an issue arises that both sides knew was going to come up, and then you have to take ends up being an hour break, and then it's 11:45, and one of the jurors is hungry, and you take your lunch break, and you've lost a couple hours there. So certainly just think ahead of what's going to arise, and not just your strict motions in limine that you have in every case, but based on your evidence, what you're going to be fighting about, and fight about it in advance. And strategically, I recognize that doesn't work in every case, and there might be reasons to wait, but I would encourage you to try to bring some of them up in advance.
Judge Sands, I assume you would agree with that, but would you also concede that sometimes lawyers feel they need to file a motion in limine, realizing they may lose, but they just need to have a vehicle to talk to you about an issue?
Yeah, I agree. I agree exactly what Judge Boulee said. If it's something that's critical and significant, that's going to require time, then it should be raised early. And my caveat is, though, it's kind of as suggested, is what I do not like is motions in limine about routine, regular matters that a lawyer has an obligation to object to at trial. There's nothing fantastic about the evidence. It's a hearsay objection. It doesn't take 5 minutes. The question is heard, and the objection is made, it's ruled on, and you move to the next question. Okay. And there's a technique I think some people may use effectively or not so effectively to, I guess, cause the other side's case to be more revealed than it might otherwise be by very strategically making certain motions in limine. And that gets away from it, in my opinion, away from what its real purpose is. I have kind of the old-fashioned kind of common law view of what motions in limine are designed to. That is to identify evidence that is clearly inadmissible, but is also so prejudicial till, you know, the usual corrective instructions and things will not correct it. So that obviously does not include normal, regular objections. Those are just regular things. So when I see a lot of this, a series of questions, he may ask him about this, that, or the other that requires nothing more than a regular objection, you know, then I don't think that's a good use of my time in reviewing it, and nor the lawyer's time. But clearly, if it's something significant, we want to get it beforehand. As the judge said, no one wants to stop in the trial for an hour when you could have done that before the trial. And I know in my cases, I try to get everything identified as I possibly can that's going to require a judge-lawyer decision outside of the jury's presence. The other caveat that I have to motions in limine is this: sometimes the evidence that's presented in the motion is not exactly the context and circumstances that evidence is going to take at trial. So I'm real hesitant to make an absolute ruling on something that I've not actually heard the full context. So if it's identified in the written motion and it doesn't require a hearing as such, what I've used as a device to both benefit the movement and to protect the other side as well as my opportunity to make an informed decision is that I will just say neither party can make a reference to this during the trial of the case, nor any witness, unless and until the court has been noticed that you're about to raise this issue before the jury, and let me know that, and then we will do that. So that allows the evidence in the case to have been developed, so I have a much better context to hear what is the actual objection. So, but that's the other device that I use. But I think they can be very helpful, but I think they can be abused if used for reasons other than what their real purpose should be.
So 2 other topics. For the purpose of our hypothetical, we're going to assume there is a conviction, since the discussion topic is technically sentencing. But let's talk, if we could, about 2 functions of 2 parts of this process that are so important as it relates to the jury, and that's jury selection and jury instruction. Wow. Some people advocate strongly detailed questionnaires. Some judges like them a lot. Some judges want to get down off the bench and talk to the jury and do it themselves. In some state court practice, there's a lot more leeway in, I won't say fully pre-trying your case, but certainly having a broader discussion of some of the critical issues that are going to come up as you're trying to identify jurors who can sit fairly and put aside whatever it is their own background might be. And then the flip side of that is the trial's over and we now have to instruct the jury. Lots of the cases that the lawyers in this room deal with don't have pattern jury instructions. There'll be some unique piece of a particular statute or federal regulation that the jury's going to have to render a verdict on, and it's not just the drug trafficking pattern instruction that's been approved 100 times before. So if you could talk about either one of those phases, I think it would be helpful, and then we'll get to sentencing.
Okay, well, as far as jury selection, I think that's something that differs pretty dramatically at least, I don't know anything about Florida State Court, but Georgia State Court versus federal court. I think the practice with many, if not most of the judges, at least in the Northern District, I don't profess to have much knowledge in the Middle District, is that voir dire is fairly limited. And with some judges, it's even done almost entirely by the judge. Superior Court in DeKalb County, at least in Division 6, my division, I I let the lawyers try their case, and I always thought that part of that was giving them a fulsome jury selection. Let them ask their standard questions of the entire panel, and then follow-up questions individually. And I was loath to ever cut them off. I think it's an important part of the case. I want them to understand who they're picking. Now, having said that, I think it's the questions there are, can this juror be fair and impartial in this case? I didn't see it as, I know as an advocate, I would want to introduce some of my themes and that sort of thing. And as a judge, I don't see it as a theme introduction device. I see it as a device to make sure you're picking fair and impartial jurors. And so I do step in if I think somebody's starting to introduce their themes or asking questions that have nothing to do with that. And the way I handle that is I don't do that in front of the jury. I'll just say, counsel, can you approach? And I'll let them know that they're veering off and that this is their warning. And the second time, I will cut them off in front of the jury. And usually there's not a second time. Yeah.
It's a bit different in federal court. It kind of varies. I think there are some federal judges who do, as most of you are probably aware of the way most state judges would do it, a pretty broad way of doing it. I have a modified way of doing it, and it's really based on my view of what I think the process is supposed to do. Now, we can say we're looking for a fair, totally impartial juror. If you're the plaintiff, you're looking for those jurors who are going to favor your case. And if you're the defendant, you're looking for those jurors who might not go along with the plaintiff. So the idea that we're looking for this perfect group of people, that's not what we're really looking for, because everybody can identify the other side's best people and knock them off. What I think you're looking for are people who will honestly consider the evidence and give your case or your defense or claim fair consideration and follow the law. That's what you're really, and between the two sides of the whatever number involved, the more favorite juror from the other side is going to be picked off and vice versa. So you kind of work out with a middle. So I think it's important for the trial judge to make it clear as best he or she can to the jury that everybody wants an honest answer from you. That's what I think benefits lawyers. If someone's just blowing smoke at you to look, smile, and to be liked by the lawyers, that's not really going to help you very much. It's getting an honest answer. So the message I try to give from the judge's point of view is these lawyers need to know, the parties need to know something about you and what your views are so that they can decide who's best to serve in the case. If you're not selected, doesn't mean you're bad. If you are, doesn't mean you're perfect. So that's kind of the way I look at it, is setting up that type of a forum and environment. And I will ask the initial questions, and the lawyers would have provided questions to me in advance, but I'll allow the lawyers to immediately follow up on any responses. If a juror responds to my question, they can immediately follow up with that juror, and I give them the time to follow up later with additional questions they may want to ask to develop further things that responded. So my point is not to prevent the lawyers from having a broad involvement or to get the questions asked if they want to, but when you've got 50 jurors and they're trying to say, you shouldn't bring in more than 45, and one question gets asked to a general group of people, and a response comes out that puts in jeopardy the remaining jurors' qualifications, so you start over again, that's problematic. The more experienced the lawyers are and the more thoughtful the lawyers are, the less likely that is to be the case. But and you don't worry about it as much. But there are folk who've gone to a seminar and they heard about a question that was asked. so they can't wait to ask that question, and it just creates havoc. So I kind of want to know in advance kind of what you're asking, and that's what I'm worried about, is not having a disaster with the jurors being unnecessarily disqualified, is not to prevent lawyers from asking questions about a matter. And one additional thing I would suggest to you, that the kind of judge-driven hybrid, there are some questions I would have been loath to ask of a juror if I was the lawyer in the case. Mm-hmm. You know, you have to, those kind of questions, it's like cases involving sexual misconduct on trial, and you're either examining on direct a victim or worst of all, you're cross-examining the victim. So you got a jury panel and that you want to ask them some sensitive questions. I think those questions that you want to ask can be asked by the judge with less consequences to you. Mm-hmm. And you can be in present, watching and listening when that question is asked. So that's something to think about. Or a questionnaire can be used to ask some of those types of questions to get the preliminary answers, and then you can more privately follow up on it. So I don't think there's any fixed way that's perfect all the time. But I think some variations are sometimes purposely and sometimes just having to adjust would make sense. But I think everybody has the same purpose in the end in terms of what's accomplished.
All right, so tragically, the case is over. For the client, the verdict is guilty, and we're now set for sentencing. That important step that you mentioned in the bonds set, talking with the probation officer and the officer who's going to prepare the sentencing memo, sometimes overlooked in terms of talking to your client, preparing them, how you're going to interact with that office, and understanding how that earlier interview is going to play into the report that's ultimately going to go to the judge. But Judge Boulee, if you could talk to us a little bit about how you approach sentencing, how you approached it in the state court, how you will approach it in the federal court. You received strong accolades for your work in the veterans courts here in this community. There have certainly been other courts like that around the country, whether it's a mental health court, drug court, that have become so important, frankly, in handling community issues. But those have a different mentality and approach to the defendant. In cases where there's been a jury verdict, the approach is going to be perhaps a little different. Help us understand how you will prepare for and approach those.
Sure. That I think is one of the greatest differences between my old job in Superior Court and my new job in the district court, and something I'm fairly enthusiastic about is the pre-sentence reports that you get as a district judge. And I think there are a handful of people here who do cases in both federal court and Superior Court. In some of those cases, if it's a 3-week-long murder trial, I may get something like that in Superior Court, but I would say in probably 95% of the cases in Superior Court, I didn't get anything like that. Right. And a lot of times I went straight from the plea to the sentencing, and I just got a little bit of information from the defense counsel or the defendant. So I am delighted to now be a part of a process in which I will be that much better informed. Obviously, we start with the guidelines. We look at 3553. One piece of advice, I don't know if any of you know Judge Mark Anthony Scott, DeKalb County Superior Court. He was a mentor of mine. I was fortunate to have a number of good mentors there. But one thing that he told me early on was in sentencing that there's a difference between the people that we're mad at and the people that we're scared of, and that really stuck with me, and I thought about that in my cases in Superior Court, and I'll continue to think about it in my cases in District Court. We are here at the White Collar Conference, and I think for a lot of those cases, your clients probably fit in the former category of people we are merely mad at as opposed to scared of. And that's one thing to think about when you're presenting your case. I think another piece of that, which is incredibly important to me, and this might be less so when you've had a contested trial and a conviction versus a plea, but I always loved to see what someone has already done to try to make things right. And in the white collar context, that might be a lot of times monetary, and making someone whole before you come in to your sentencing. That goes a long way with me. And there's a lot of ways. Every case is different, but think through. If your client has pled guilty, there's something to be said for that, of course, and make an argument about that. But think through, what else your client can do to have made someone whole or try to start making things right before you get to the sentencing. At least with me, that goes a long way.
Mm-hmm. Judge Sands, if you're sentencing a defendant who may have tried to make amends either financially or perhaps by cooperating with the government, what do you think is the best way to present that witness in a scenario where the government is, I don't want to say a partner in sentencing, but saying a few good things about the defendant in front of you?
Well, it's something to be taken into account. I guess it's because I spent some time prosecuting and defending. I'm not a judge who quickly looks behind an agreement between the government or the state and the defendant. I tell my clerks all the time that we never know the whole story. Seldom if ever know the whole story. There's things the judge would not know that may have been important to the case for one side or the other. So if everything has been done arm's length, in my estimation, a judge is kind of stepping outside of the judge's role when it becomes a matter of second guessing the disposition of a case that was decided between the parties. That's not to say that the judge should agree necessarily with any recommendation, but I think it certainly has to be respected that they've determined that this is a fair outcome of how the case goes. Now, the next thing that I take into account is this. There's been a lot of controversy, of course, about the guidelines that we still start with. As a general matter, I think the guidelines are a good idea. And at the same time, I'm a judge that thinks we got to have discretion. So that seems like almost like a contradiction, I'm sure. But I think I'm always uncomfortable if I give a sentence that's very severe. What is the reason I'm giving this severe sentence? I haven't given it to a lot of other people. So what is there about this defendant and these facts that caused me to end up at this point with that particular sentence? And to me, I have to be able to articulate in my own mind why that is so. Or if there's a situation where there's an extremely lenient sentence being given that generally is not so with others, so the reason is why. I think there's little justification for a broad swing in sentences between similarly situated defendants for similarly situated conduct across the country with one sovereign, United States of America. Los Angeles and Atlanta should be some difference, but it shouldn't be vast. So the guideline gives us a place to start that says, here's what we think about this conduct, and a person with this particular background, this is where they fall. Even when I was on Superior Court, I was concerned about it. Just as Judge Boulee said, I never had the resources that I have now. The probation officer may be able to tell me a little bit in a summary, And I'm guessing, but always in the back of my mind was, is this sentence fair to this person? And is it fair to this person as among other defendants? And I didn't have easy access to that at that time. I do have much easier access to it now. So the guidelines allows me to make that first broad adjustment and then to look to see whether there's some reason that it should be up or down from that. And to me, there's nothing more important than sentencing for a trial judge. I mean, that's real impact on real lives, and to be taken lightly, I think is a disservice to everybody involved, but it is also one of the most challenging things. So I think if you're thinking about fairness and equality, but yet thinking of the individual. So from a defense perspective, I think the general thing you want to do is to make sure the judge is seeing an individual. All those things that make that person somebody who is valuable and worthy of being given full consideration for a fair sentence. I think that's what you want to do, as opposed to allowing the judge to fall into the trap of the group. I should say the angry. This is somebody we're angry with, or here's somebody in the flavor of the month type of violation. But that's generally my viewpoint of how I approach it. So I'm very much listening to the reasons why this sentence should be less, but I'm not likely to question the general settlement of the case as between the parties, because I think that's something that's within their purview to do, unless there's something really out of order that I probably will not at all second guess or question.
And Judge, your comment about the arm's length transaction between the two parties raises the question in my mind of C pleas and a defined agreement as to what the actual sentence is going to be. In state court, in many states, that is 99% of how all cases are handled. A defendant knows that he's going to go in and he's going to plead and he's going to get 38 months or whatever the agreement is in that case. The challenge in federal court in talking to clients is the unknown so often. And yet there are some components within the department where C pleas are more favorable within their management structure than others. I think you have some U.S. attorneys that are more inclined to put in a C plea provision or permit C pleas than others. What do you see over the course of your years on the bench, and really, if the parties have agreed that this is the appropriate thing, why shouldn't that always be given great deference?
They're the rare ones. I think in our.
But why are they so rare?
Well, I guess again, I don't know that the parties have that meeting of the mind. I think that's what happens. They don't come to that place where they agree.
Right.
And again, I still have the same fear. Again, I'm not, even with the C plea, I'm not so much questioning the recommendation reached between the parties as they rarely do. I'm still worried about the overall, how that case fits in the panoply of other cases. Mm-hmm. So what I'll do is I'll just tell the defendant, okay, I'm going to let you make your plea, but I'm not going to act on this until I've seen the pre-sentence investigation report. Once I've seen the report, I will let your lawyer know in advance whether based on that I will or I won't accept the C plea. If you don't accept it, there's no problem. You're not going to get burned by me because you made your choice. It's your absolute choice to make. Or you can say, well, okay, you can stay with it if you want to. Because sometimes the difference I have may be very tiny. It may be that that someone is saying 9 months, and I think maybe 12 months is probably a better sentence. And that's probably still better than the risk of the other way around. Right. So I let them know that. And if it's something that I have what I think is a fair sentence in mind, I will, without getting involved as a negotiation matter, I will make that known and so that they can take those things into consideration. But I think that's the problem with it is you can't get that certain. Like you say, it's hard to get certainty, but I think it's for reasons not to deny the defendant of certainty, but because other people, players, particularly the judge, needs to know some other things before they can sign off on that or not. But I don't think I've had any, I can't recall of a C3 that fell apart totally because of my decision to either reject or to accept it in the way that I just said I do it.
Well, we haven't been interrupted by anyone in the audience, but I hope that there are people in the audience who have questions and or have thoughts they want to share about these topics. So if you do, before we run out of time and Joe throws us all off the stage. Yeah, Brian.
So both judges, there was an interesting discussion first thing this morning on discovery, Rule 16 discovery, particularly with the advent of significant volumes of discovery in the computer age, and what, if anything, can or should be done as it relates to amendments to Rule 16 or other obligations that we may impose on the government to identify Rule 16 discovery among millions and millions and millions of pages of discovery that are often produced in economic crimes cases.
You want to start?
I sat here and I very much appreciate the presentation this morning. It was wonderful and frightening because I know this is what's been coming, and I've had a couple of cases where it's kind of come up, but it did not result in a conflict. They were corporate groups, and so they could afford it and that sort of thing. So it did not come to a full clash. In the discussion about the rule change, now in my civil side, the discovery rule has been changed over the years, and each time it goes towards judicial participation in the discovery process. Again, as judges, you guys go ahead and get your case ready and let me know when you're ready to go to trial, and we'll get a trial. Otherwise, don't call me. When I started out, though, I took a different viewpoint, and I've kept that one. With few exceptions, I hold discovery conferences in person in all the civil cases that I sit on, that I try. And I've stuck with it, and I've had lawyers say to me privately that they think it's a good idea too. And it gets me involved in the process and to identify these problems. So I would not have a problem with a Rule 16 requirement in a criminal case to hold conferences, because as busy as we are, I think we're busier without managing or being involved than the other way around. That's what I've found in my civil cases, because I can identify in 5 minutes the case that I'm going to have a lot of difficulty with. Those cases are very obvious. I'll say to my clerks, okay, we're going to have to be real close to them for a few months until they get together. I mean, really, it's obvious. In other cases, from working together to work up a plan, and with the judges involved in approving and then being available for any little differences, those cases go much better than the case where you all go ahead and agree, and when something happens, call me, which is almost inevitable. So I can see that that's a benefit, I think, to work out, particularly in these very complex cases. Maybe for the routine criminal cases, it would not be necessary, but those cases with all the metadata that you all talked about this morning, I think you're going to ultimately wind up anyway with a quasi Rule 16 meeting at some stage in that case. And I think it will make far more sense and be much more cost effective and practically effective if it was done as a routine matter early in the case. So I'm sold on that already, so you don't have to convince me, but I'm also scared to death of what I'm going to do with these terms. I just found out there's another name for a PDF. I had no idea what it was. I also know at trials, I always ask the lawyers, what am I going to learn new this time that I didn't know, which is wonderful. Do you know what it means when they say this phone call may be recorded for quality purposes? Does anybody know what that means when you hear that recording? Well, I had a criminal case that involved fraudulent tax returns, and I found out what that meant. What it means is at the time of this call, we were recording the time of this call, its duration, from what number it was dialed. That's the recording. It's not the recording of the voice message. So you can find that a call was made from this phone to that phone at this time of the day, and it lasted 3 minutes. That's the data. And I did not know that until I was in the middle of a criminal case when they were able to track these every time the people who file fraudulent tax returns, every time they call the IRS or the money distributor to check on the status, it was recorded. They used a computer that was off-site, but they used their own cell phones and their home phone when they called to check on the status of the returns. And that's because of that recorded contact is what that is. So for years I heard that recording. I said, oh, they're going to check and see, they're listening to see whether they're really giving me good service. That's not what it is. So I know that I'm going to learn more about metadata than I ever dreamed I wanted to know, but I'm prepared. I think it's necessary. There's no way to avoid it from the time that we're living in and expected to live in. I think even we boomers we've got to catch up, and and this judge will rely on you lawyers to help me catch up.
Well, do we have one last question before we let everybody break for the day? I know there are some very nice events that are scheduled for this evening. But if you have questions, you want to ask them now, or if you see the judges in the hallway, I'm sure they'd be glad to chat with you too. Well, thank you all for coming. Thanks for participating, and thanks our two judges for being with us today.
Okay.